We will go on the record in the matter 24 CT08, State of Wisconsin versus Brent Reynolds. The state appears through Assistant District Attorney Jose Vila in person. Mr. Reynolds appears in person. Ms. Philomena Quebec appears by video conferencing with approval of the court. We're set today in this matter for a status conference. Ms. Quebec, please update the court.
Hi, Your Honor. So I believe that we are interested in entering a plea. I'm not sure if we're able to do that today.
Yes, please.
Okay.
So he wants to plead to the charge of count 1, DRI the second for costs only. Is that correct?
Yes, Your Honor.
All right. Okay. And so, Mr. Reynolds, you wish to accept the offer?
Yes.
And your attorney is appearing by video conferencing? Do you understand you have the right to say, you know what, I want this to be on a day when she can be here in person?
No, it's fine.
But you are okay with her appearing by
Yes.
video?
Yes.
If you can't hear her or see her, she's over there in that big monitor.
Sure.
Let me know so we can make sure that you've heard and you've understood everything, okay?
Okay.
And if at any time you have any questions or concerns and you need to speak with your attorney, let me know. And I will briefly adjourn the hearing so you can either go out and give her a telephone call, or I can put you in our Zoom room and set you up with a confidential breakout session, okay?
Okay.
All right. So how old are you, Mr. Reynolds?
I'm 42.
You can read, write, you understand the English language?
Yes.
Any drugs, alcohol, or medications in the last 24 hours?
No, Your Honor.
Any mental illnesses or disorders that you are treating?
No.
Do you understand that you would have the right to a trial? You would have the right to have your attorney cross-examine the state's witnesses or call witnesses to testify for you. You would have the right to testify on your own behalf or remain silent and not have your silence used against you. You would also have the right to have a jury trial in which 12 of your peers would need to reach a unanimous decision as to a guilty verdict or find you not guilty. And you would also have the right to have the state prove your guilt beyond a reasonable doubt. Do you understand all of those rights you're giving up?
Yes, I do.
Do you understand that if you're not a citizen of the United States, your plea could result in your deportation?
Yes.
Do you understand here, the state would have to prove on or around January 9th, 2024 in Burnett County, Wisconsin, while being a person whose operating privileges had been revoked pursuant to Wisconsin law, you did operate a motor vehicle on a highway during such revocation period or thereafter, and the revocation was a result of an OWI or similar related offense. Do you understand that?
Yes.
Do you understand the maximum possible penalty could be a fine of up to $2,500 or imprisonment of up to 1 year in the county jail or both?
Yes.
Do you understand that there is a recommendation by both parties for costs only, but I don't have to follow that? You understand that?
Yes, I do.
I could sentence you up to the maximum possible penalty if I thought it was warranted.
Yes.
Now, did you go over the criminal complaint with your attorney, that charging document where it basically says what happened and why you were charged with the offense?
Yes.
For the most part, are those facts accurate?
Yes.
Admitting here today, you in fact did operate a motor vehicle during a period of a revocation?
Yes.
And you knew you were revoked?
Yes.
Ms. Quebec, may the court use the probable cause section of the criminal complaint to find a factual basis?
Yes, Your Honor.
Has anyone made any threats or any promises to you, Mr. Reynolds, for you to plead guilty today?
No.
You're doing so freely and intelligently, telling the court you fully understand what you're doing?
Yes, I do.
And voluntarily?
Yes.
Has your attorney represented you competently?
Yes, she has.
Has she's answered all of your questions?
Yep.
She's done a good job because she had the other matter dismissed, right?
Yeah, she's done a very good job.
Yeah, and so she's talked to you about any defenses and all of those things and that you can go to trial?
Yes.
And are you satisfied with her services?
Yes, I am.
Okay, so any questions right now for your attorney or for the court?
No, Your Honor.
As to count 1, operating motor vehicle while revoked, how do you wish to plead?
I plead guilty.
Court will find your plea of guilt is done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your plea of guilt. Based on that, I will find you guilty of count 1. Count 2 will be dismissed and read in for purposes of sentencing. A judgment of conviction will be entered today. Argument, Mr. Vila.
Thank you, Your Honor. I believe the joint recommendation for cost is appropriate. Mr. Reynolds is here taking responsibility for his actions. Furthermore, it's an operating while revoked. It's not the most serious offense before the court here today. I think cost is more than enough to deter him from doing it again in the future. Thank you.
All right, thank you. Ms. Quebec?
I've gone over this with my client, and we are satisfied that this is fair and appropriate. Thank you, Your Honor.
Thank you. Mr. Reynolds, anything you want to add or you want to tell the court?
No, I just like to get this over with. It's been going on for a while, so
It has.
it has a long time.
And so I am glad you are stepping up, you're taking responsibility, you're being accountable. You are still in the process of getting your license.
Yes.
You still have to work out a few things. And so that's what has drug it on for as long as it has been going. And here we're going on 660 days almost. You're gonna get your license, otherwise you're gonna be back here again, starting all over, ticking that clock.
I know.
So hopefully that's not gonna be the case. This is a low end crime. So what the court's gonna do is all I'm going to do is assess the DNA surcharge of $200. All right. I'll waive the rest of the court costs and fees. I'm doing that because you have bigger fish to fry.
Yep.
You have child support. You have to take care of those. It looks like we still have $500 cash in this case. And so I'll use $200 of that to pay your court costs and fees. With regards to the rest, as you have stated previously with other cash that's been posted, that the remaining $300 will go to help bring down your child support.
Yep.
Still okay with that?
Yes, I am.
All right. So we'll take 200, we'll send 300 to child support. Hopefully that'll keep getting you whittled down and you can stay out of trouble, Mr. Reynolds.
Yes, I will.
I like Mr. Reynolds not in trouble versus you here for any matters, okay?
Yeah.
You have 20 days to appeal. Should you fail to appeal, you do lose that right. I do need to order your DNA. So when you're done here, you're gonna go to the jail, see if they need it. If they do, they'll take it. If they don't, they'll send you on your way. You have the ability to request your DNA be expunged through a written letter to the Department of Justice, not to this court, to the Wisconsin Department of Justice. It's easy to do. Google it, or you can ask your attorney. She can explain it to you. It's just a simple letter.
Okay.
I think that covers everything, Mr. Vila.
I do see that he was picked up on a warrant for failure to appear back in May. I don't know if there's jail credit that's attached to that, since it was also for a child support issue.
I'm just gonna let the child support. He set a hefty sanction for it, and
That's fine. I just wanted to
fine.
clarify.
It's just a fine. Anything else that I'm missing, Ms. Quebec?
No, Your Honor. Thank you.
All right, thank you. We are good to go.
Thank you.
Now, don't forget to go see if they need your DNA, okay?
Oh.
Thank you. All right, we're adjourned.
Yes, I can, Your Honor.
And Mr. White, you agreed to accept an appointment of Jacqueline Taylor's case, correct?
Yes, that's right.
Excellent. Okay, I have her here. She's ready to go.
Okay, good.
We will go on the record in the matter 26 CF 59, State of Wisconsin versus Jacqueline Taylor. The state appears through Assistant District Attorney Jose Vila in person. We have Mr. White appearing by video conferencing. Ms. Taylor is in person. We're set today in this matter for an initial appearance. Mr. White, were you able to go over the criminal complaint with Ms. Taylor?
Yes, I was, Your Honor. There's one count in that. We reviewed the penalties. I acknowledge receipt of the complaint, and I can waive further reading on that, as well as waive the time limits on any preliminary hearing.
Thank you for waiving time limits. That makes things a little bit easier. I could do an August 3rd at 3:15.
Let me see. August 3rd.
If it's a waiver, you may appear by video conferencing, Mr. White.
Your Honor, right now I'm scheduled for some double booked trials in Barron on that day. I better avoid it for right now.
That is totally fine. August 31st at 3?
First. That'd work for myself.
All right, so August 31st at 3 o'clock, okay?
Okay.
And I believe you are closer in Grantsburg. Talk to your attorney. The next hearing is what's called a preliminary hearing, where the court determines whether or not there's probable cause.
And that's a wrap. This hearing is a reminder that not every courtroom story ends with dramatic prison sentences or shocking twists. Sometimes, accountability means accepting responsibility, negotiating a fair outcome, and moving forward. In this case, the judge balanced punishment with practicality, waiving most costs while encouraging the defendant to finally get his license and stay out of legal trouble. But what do you think? Was this a fair resolution? Or should repeat driving-related offenses face tougher consequences? Let us know your thoughts in the comments.